So I'm going to throw Robert a couple of additional questions just to see what happens. So Robert, a situation. I have either had a stroke and so I can't use my dominant hand to sign, or I'm no longer able to actually physically do the signature, but I know what you're asking me. I just don't have the ability to sign papers. Does that mean I lose my ability to be the signature of things?
Technically, no, but it's also going to depend on the state that you're in because the rules are going to be different. And in Virginia, at least, you can direct me to sign the documents for you.
Okay.
In some instances, you can have some assistance to sign those documents. And I'll give you one quick little experience that I had. The individual ended up having a stroke, was not able to speak, but was able to blink and understood everything that I was saying to her. And by blinking, answering yes or no to me. And we went through the entire power of attorney, line by line, reading it to her. And at the end of reading it to her, with the agents that were listed, she had approved everything. And then she directed me with a yes blink to sign on her behalf. You can do that through a will, advanced medical directives. You can have assistance in that, whether that's a guidance of your hand on the signature or just help in some general formality. Advanced directives can also be oral to the doctor if you're not able to sign. And so there are sometimes ways that we can help those individuals who cannot physically sign but have the competency to do it. Correct.
All right, so if I had that lucid day and I'm very good, except my motor skills are still impaired. Let's talk then about a situation where I have done nothing. As a couple, we've done nothing. As a parent-child, I've done nothing. There's nothing. So I'm now in a position where my abilities are significantly impaired.
Okay.
Are we just stuck and we go to guardianship?
That depends.
Okay, so it depends.
So you said significantly impaired. On the day you meet with me, are you still significantly impaired?
Okay.
And if you're not on that day, then I'm going to quickly go ahead and get documents put in place. Okay. But if you are significantly impaired or your spouse is, then you and I have a discussion on what we need to do next. And that could be the guardianship, conservatorship. It's going to depend upon what access do you need. Is there an IRA, 401k, properties in one individual's name and you have no access because the power of attorney is not in place? Or are they all joint accounts and you have access to everything? And then we talk about the medical decisions. Code of Virginia allows, without advanced medical directives, certain individuals in order to be able to make the medical decisions for you. So you may not need to go the guardianship route because you have the ability still to make the medical decisions. So you don't necessarily jump straight to a guardianship or straight to a conservatorship. It's going to depend on the family's dynamic and how the accounts are and the situation we're sitting in at that moment. And each of those issues and family dynamics are specific to that family. So I always encourage individuals to come in to see what we need to do for your respective family at that moment.
Okay. And families can get really messy. Second marriages, two different families, there's funds involved, there's resources involved. So getting someone involved as soon as possible to try to sort through this is vital. But let's say I have a really, really old document, and since that time, there was a divorce, there was a separation, somebody died, and now we have an out-of-date document that's not really where I am right now, and I need support and help, but...
Most of the time, if there has been the divorce, that makes it easy because most states are going to have that if you have been divorced and you have listed your previous spouse as an agent, they no longer are able to serve automatically because of that divorce. And it falls down to the next agent if you have one. If you don't have another agent there and you have no ability to sign new documents, we're probably looking at a guardianship and conservatorship.
Okay. So let's pick one more little situation. Let's do one more. And then this one, the situation is that you want me to be your healthcare advocate, my healthcare power of attorney, durable healthcare power of attorney. The challenge is what exactly am I agreeing to, number one. But more importantly, I look at what you want for yourself and where I feel comfortable and I don't feel comfortable. It's not a space that I'm comfortable in. And what I would want for you is really different than what you would want for you. And I don't know if I'm the right person for this.
If you feel that way,
Yeah.
then you decline to serve.
I should decline.
You should decline. You would
Okay.
obviously you're going to look at the document and you're
Yeah.
going to see who's below you. Is there someone listed below
No.
you? And if
And
there's
that's-
not, and you feel truly that strongly that you
Yeah.
are not capable of serving to provide the decisions that this
Because what he
individual
said he
wants,
wants is just like,
then at
I
that
don't
point,
agree with it. It's really hard for me to agree to. I mean, I'm just trying to be honest in my reactions because
correct.
I don't want to be in that position where I'm making a choice that I feel is wrong.
Are you comfortable filing a guardianship so that someone else can make that decision?
So he gets what he says he wants, and I don't have to be the one to do it.
Correct.
I think that
And
would
the
be
first
better.
question is this individual still capable of making their own decisions?
No, but he was really clear when we did this that that's what he wanted. And
Okay.
at the time, I was hesitant, and I know I can't now.
Okay. Well, then we could file a guardianship petition.
Okay.
We can incorporate the wishes that he has
Okay.
that are currently inside his advanced medical directive into the guardianship order.
Mm-hmm.
So his wishes are still carried out, but by not you, but by someone else.
Okay.
Or another entity, Jewish Family Services, Catholic Charities,
So
other
there's another
professional
group
fiduciary
that can do
entities
that,
that can handle
an ad
that.
litem. So let's switch it and let's say I do want to advocate for you, and I'm getting pushback from either some of the medical community who have different thoughts or opinions about it, or perhaps some of the family members who are listed next. But I'm the person who was. How do I go about advocating? What are some of your recommendations about my advocacy versus fighting?
With the family members?
With family members or
anyone?
with a medical provider saying, yeah, I'm doing this against medical advice. I understand that. But that's what I'm holding true to what we
Correct.
agreed upon.
You just did it.
Oh, okay.
By saying what you're saying and repeating it over and over again
Yeah.
to that medical provider.
Okay.
Because sometimes they need to hear it over and over again. Sometimes they need to hear it from a letter from an attorney occasionally, very, very rarely.
Okay.
But I have situations where we are very specific inside those advanced medical directives because of the diagnosis the person's received. They don't want this, they don't want that. They're adamant they don't want any medications for any purpose whatsoever, whether it's pneumonia or otherwise.
Right.
Because they want to pass. And that is what you advocate for. It's written down, they signed it, it's notarized.
Yeah.
So it is perfectly fine for you to advocate for that person.
Okay.
You shouldn't feel bad about it.
Thank you.
You're very welcome.